Hello, my name is Nduka Njoku. I'm your lecturer for PUL 446 Law of Evidence 2. Today, we are going to discuss an important and interesting topic in the Law of Evidence. And that topic is hearsay evidence. At the end of this lecture, you will understand what is the meaning of hearsay evidence and why it is excluded in evidence. You will also understand the different exceptions in the Law of Evidence and why those exceptions are allowed by the law. I believe that you will appreciate today's lecture. Thank you.
Allowed by the law. I believe that you will appreciate today's lecture. Thank you.
Let us start by defining hearsay evidence. Generally speaking, oral and written statements made by persons other than the witness who is testifying are not receivable to prove the truth of the fact stated. Evidence of such statements are said to be hearsay evidence and therefore excluded. So if it is thought that B slapped C on a specific day, it is not permissible, it's not admissible to call a witness to testify that W told him that B beat up C on that specific day. W himself should come to court and testify if he was present. And this is recognized by the Evidence Act. Section 37 of the Evidence Act says that hearsay means a statement A, oral or written, made otherwise than by a witness in a proceeding, or B, contained or recorded in a book, document, or any record whatever, proof of which is not admissible under any provision of this Act, which is tendered in evidence for the purpose of proving the truth of the matter stated therein. So essentially, what makes hearsay evidence inadmissible is the fact that the witness who is testifying is offering that statement made by another person in proof of the truth of the matter which is in issue. That is what makes it inadmissible. But if the witness who is testifying is just stating that that particular person that is not before the court made that statement to him, then that's admissible, because he is not offering that statement in proof of the fact in issue, but offering that statement to show that that other person not before the court made that statement. Let's look at section 126 of the Evidence Act. It said, oral evidence shall in all cases whatever be direct. If it refers to A fact which could be seen, it must be the evidence of a witness who says he saw that fact. B, to a fact which could be heard, it must be the evidence of a witness who says he had that fact. C, to a fact which could be perceived by any other sense or in any other manner, it must be the evidence of a witness who said he perceived that fact by that sense or in that manner. D, if it refers to an opinion or the ground on which that opinion is held, it must be the evidence of the person who holds that opinion on those grounds. Now there's an exception, there's a proviso to that to D. It says, provided that the opinion of the experts expressed in any treatise or sale and the grounds on which such opinion are held may be proved by the production of such treatise if the author is dead or cannot be found or has become incapable of giving evidence or cannot be called as a witness without any amount of delay or expense which the court regards as unreasonable. In other words, the Evidence Act is demanding that anybody who is coming to court to testify must testify as to the issues that he saw, that evidence must be direct, oral evidence must be direct. If it relates to a fact you saw with your eyes, then you have to give evidence of what you saw and not what another person told you that he saw. If it relates to evidence that it relates to evidence of what you heard. It must be the evidence of somebody who heard it and not what another person told him that he heard. If it's evidence that was perceived by somebody, it has to be the evidence of the person who perceived it and not otherwise. And if it's an opinion, it has to be the person who holds such opinion, except that person who holds such opinion is incapable of giving evidence or is dead. Then that opinion may be contained in a book, can be tendered in evidence. Let's look at the reasons why hearsay evidence is excluded. Cross and Tapper says that it is largely because of the increased dangers of impaired perception, bad memory, ambiguity, and insincerity, coupled with the decreased effectiveness of conventional safeguards, that hearsay is regarded as so particularly vulnerable as to require a special exclusionary rule. What Cross and Tapper is saying is that because human memory is not reliable, sometimes people forget what they heard, and that when opinions or stories move from one person to another, people either deliberately or inadvertently change such stories, perhaps sometimes out of bias or because they could not remember exactly what was said to them. And importantly, the person who made that statement is not in court and therefore cannot be cross-examined to determine the credibility or veracity of the statement that he is making. In the next slide, you will be expected to provide answer to a question contained in that slide. Discuss the nature of hearsay evidence. Let's look at the exception to the hearsay rule, because the exclusion of the hearsay evidence is a general principle of law. There are exceptions to it. Section 39 of the Evidence Act states that statement made by a person who is dead, who cannot be found, c. who have become incapable of giving evidence, or whose attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appears to the court unreasonable, are admissible under section 40 to 50. That section is saying that if somebody is dead and he cannot be found, or are becoming incapable of giving evidence, or is difficult or becomes unnecessarily expensive to procure the person's evidence, then that person's evidence can be received under section 40 to 50. Let's look at another exception to the hearsay evidence: dying declarations. Dying declarations of persons since deceased who obviously cannot be called as witnesses are admissible as exception to the hearsay rule. This is because such statements can be tendered not just to prove that they were made, but the truth of such assertions. Let's look at section 40 of the Evidence Act. But for such exception to be admissible in court, there are certain conditions that must be met. A. The declarant must have died before the evidence is sought to be given. It must relate to the cause of death of the maker or any of the circumstances of the transaction which resulted in his death. C. The declarant must have, at the time of making the declaration, believed himself to be in the danger of approaching death, although he may have entertained hope of recovery. The condition C differs significantly from that of the common law provision. Under the common law provision, for that statement to be receivable in evidence, the declarant must have believed that he is in a settled, hopeless expectation of death. But under the Nigerian law, the declarant would have believed himself to be in danger of approaching death, although he may have entertained hope of recovery. Let's look at the case of Hearsay versus State, Rood and versus Woodcock, and other cases stated on the slide. Now, what is the rationale for admitting dying declarations as an exception to the hearsay rule? We may have to look at the case of R versus Woodcock, where the court said that the general principle on which this species of evidence is admitted is that they are declarations made in extremity, when the party is at the point of death, and when every hope of this world is gone, when every motive of falsehood is silenced, and the mind is induced by the most powerful considerations to speak the truth. A situation so solemn and so awful is considered by the law as creating an obligation equal to that which is imposed by a positive oath administered in a court of justice. So the law believes that when people are at the point of death, they are unlikely to lie, because there's no motive again for them to lie. Let's look at statement made in the ordinary course of business as another exception to the hearsay rule. Section 41 of the Evidence Act contains that exception. What are the conditions for such admissibility, or for the admissibility of such exception? A. The statement must have been made in the ordinary course of business. B. The statement must relate to acts performed by third parties, provided they are within the maker's knowledge. Let us look at the case of R versus Lawani as an authority in that regard. Let's look at other exceptions to the hearsay rule, especially Section 42 of the Evidence Act. It states that statement against interest of maker with special knowledge. When somebody makes statement against his own interest, then it's an exception to the hearsay rule, because it's unlikely that somebody will make a statement that is against his own interest. You look at the case of Sussex Peerage case. Now, another exception is a statement as to public rights, custom and matters of general interest, Section 42 of the Evidence Act. Another is statements relating to the existence of a relationship, Section 44 of the Evidence Act. 7. Declaration by testators, Section 45 Evidence Act, and evidence given in previous judicial proceedings, Section 46 of the Evidence Act. In the next slide, you will be required to provide an answer to a class activity therein. Discuss the exceptions to the hearsay rule. Today we have looked at the definition and the meaning of hearsay rule or hearsay evidence, and we've seen the reasons why hearsay evidence is excluded. We have also considered the exceptions to the hearsay rule. I believe you've been able to find the lecture interesting and informative. Thank you.